docket is Calvert versus Nation Star Mortgage. Good morning, Mr. Stopa.
Good morning, Your Honors. May it please the Court. I'm Mark Stopa, counsel for the appellant. Would request 5 minutes for rebuttal.
Okay.
Your Honors, this was a final judgment of foreclosure of an FHA mortgage. The issue that I'd like to concentrate on is that first issue in the initial brief. First, recent Florida law has made clear that the face-to-face counseling requirement in 24 CFR 203.604 is a condition precedent to foreclosure. The 5th DCA has ruled that way twice. The 1st DCA has as well. And those cases also make clear that dismissal is required upon a failure to comply, just like in the paragraph 22 cases, of which there are many. Dismissal is the remedy when you don't prove compliance with a condition precedent as part of the prima facie case. Now here, it was undisputed.
Mr. Stope, before we get there, let's push that aside. And before talking about condition precedent, one of the exceptions to that face-to-face is that there has to be a requirement that there's an office within 200 miles, because I know that was hotly debated. Here's my question to you, and help me out. This was an evidentiary hearing, correct?
A trial, yes.
And then, so you had the representative from the bank saying, categorically, there is not an office within 200 miles. Then you had your client saying, no, I believe there is an office within 200 miles. The fact that there's conflicting testimony, and we're dealing with an evidentiary, and we're dealing with a trial of fact, would that be appropriate for the judge to basically accept as truth the credibility of one witness versus another and come to the conclusion that this exclusion applies?
Judge, this is not a case that turns on a credibility determination. This is a case that turns on the insufficiency of the evidence in the plaintiff's prima facie case. Okay, and here's why. The 200-mile exception was the only argument that was espoused by my opponent. And the problem here, I kind of want to start with a timeline to answer the question, because answering that question is really the crux of my whole argument. The default date was May 1st of 2012. Bank of America was the servicer at that time. The regulation required that the face-to-face interview be done before 3 monthly installments are unpaid. So before June of 2012, the face-to-face interview should have taken place, and that's also when one of the exceptions should have applied, as of June of 2012. Bank of America is the servicer then. The service transfer to NationStar doesn't take place until June of 2013, over a year later. The complaint gets filed September 25th of 2014. Then we're at trial May 19th, 2016. The plaintiff's prima facie case, they rest initially without any evidence at all of FHA, including the 200-mile issue. I move for an involuntary dismissal, and they say, let us reopen the evidence. They reopen the evidence, and all that the evidence showed, even after the reopen, is that NationStar, not Bank of America, the servicer at the time of the default, but NationStar has present tense offices in Dallas and Arizona only. Now, the present tense there is important because the trial is May 19, 2016. There was no evidence at all about offices of NationStar on the time of the complaint. No evidence at all about the offices of NationStar in the 3-month period after the default in May of 2012. The entirety of the evidence, even after they were allowed to reopen, was NationStar only has offices, present tense, in Dallas and Arizona. Well, having offices as of May of 2016, or not having offices within 200 miles as of May of 2016, is not the pertinent issue under the regulation. The pertinent question was, were there offices within 200 miles as of May of 2012, within 3 months of the default, and perhaps as of the time of the complaint, September 2014. The evidence on that issue was entirely silent. And now, So when we moved for an involuntary dismissal based on the failure to prove compliance with FHA or any of those 5 exceptions, at that point, I respectfully submit it should have been granted. And we never even should have gotten to the defense case where there was then some weighing of the evidence. Now, I understand that did happen, but under this court's decision in Day versus Amini, which I cited in the briefs, that's this court, I think was 1989, that case stands for the proposition that when a case should have been involuntarily dismissed for insufficient evidence after the plaintiff rests, you don't even consider the evidence which is introduced in the defendant's case. We never should have gotten there. You grant the involuntary...
Correct me if I'm wrong, that's not an issue that's here. Whether the trial judge allows the reopening, I guess would be an abuse of discretion.
Right, I'm not arguing it was an abuse of discretion to allow reopening. What I'm doing is, in response to Your Honor's question, I'm saying that we shouldn't have even gotten to the defense case.
We were there, we got there, the judge did not abuse his discretion to reopen, so then the question goes back to what Judge Kuzan is focusing on. What is the competent substantial evidence, if any, that supports application of the exception?
And there wasn't, which is precisely the point. Now, the way I just presented the timeline, I'm acknowledging the propriety of reopen. I'm not saying don't consider the evidence on reopen. What it was initially saying there, based on this court's decision, Day versus Amini, is you don't get to consider the additional evidence that was introduced in the defense case, because there was very little evidence in the plaintiff's prima facie case, even after the reopen. And you can consider that evidence after the reopen, but it was very limited. It was limited to NationStar has offices, present tense, at the time of trial in Dallas and Arizona. That was it. There was no evidence about NationStar's office locations at the time of the default or at any point prior to the filing of the complaint. So without some evidence in the prima facie case as to NationStar's office locations prior to the filing of the suit, and without any other evidence that any of the other exceptions apply, this case is just like Palma and De La Cruz, where the FDCA reversed and required an involuntary dismissal, because there simply was no evidence in the prima facie case. The evidence in the defense case is simply, we put on a defense case because the judge denied the involuntary dismissal, but we shouldn't have gotten to the defense case. So that's the first point that I was making there. That's different than considering the evidence that was after the reopen in the plaintiff's prima facie case. I'm acknowledging that's okay. Now, so that's the first point there. But now, even if you disagree with that, okay, and before I even get to the evidence in the defense case, and I'll get there, even if you disagree with that and you think that the evidence was somehow sufficient to show that there was no office within 200 miles before the time that the complaint was filed, submit the evidence clearly. There clearly wasn't any evidence in terms of Bank of America not having an office within 200 miles. Bank of America has offices everywhere. They never disputed that issue. And going back to the timeline, default date, May of 2012. The service transfer doesn't take place until June of 2013. Now, in my view, what they should have done, if NationStar wanted to take the position that its office locations were pertinent, they should have moved the default date such that they were suing upon defaults only after the service transfer. That is the way to, and I get the judge's position. The judge's concern was, well, if you have the initial default date, May of 2012, the regulation requires it to be done before 3 months pass. If those 3 months pass and it's not done, it shouldn't be a forever bar to foreclosure. I agree with that. I don't think you're ever going to say that it's a forever bar to foreclosure, but they shouldn't be able to ignore what the government requires in that regulation, sit on it for years, and then come in years later and say, oh, we did something now, but we're still going to sue on those defaults from years ago.
But if this is a recurring issue, let's assume it's a recurring issue.
And it is.
I guess I'm concerned with our rewriting a regulation, as you're suggesting, as opposed to, the folks at FHA who came up with this. I assume they are aware of the recurring issue. They need to fix it.
No, Your Honor, I'm saying just the opposite. I'm asking you to enforce the regulation. Don't rewrite it. They're the ones who want you to rewrite it. How do they want you to rewrite it? They want you to rewrite it to say, even though the default date was May of 2012 and we were supposed to comply within 3 months after that, we want you to allow us to prove compliance 2.5 years later.
So any subsequent holder is going to be tagged with that requirement, this 3-month period before it can pursue a foreclosure on a debt that hasn't been paid for 4 years.
If I'm understanding your question correctly, what I submit that the law should be is that if that 3-month period passes and then there's a service transfer, that the subsequent servicer or a subsequent holder, it should check and see if the prior servicer complied in that 3-month period. If it didn't do so, then it should sue on defaults only after the service transfer took place and the subsequent server complied. I believe that that's what the regulation contemplates, because what do you have otherwise? You have situations where the subsequent servicer can just, where you can have a servicer like Bank of America in this case, do nothing with FHA, ignore the regulation completely for a matter of many months, and you have a low-income housing individual. FHA is designed towards low-income housing individuals who don't get the benefit of face-to-face counseling that Congress contemplated when it set up the regulation. The servicer does nothing and just says, we're going to wash our hands of this, send it off to somebody else. And
Alternatively, a fix would be that a lender who does not comply is not going to be able to do FHA financing, and is not going to get the benefit of the insurance protections that the regulatory agency provides.
I understand that, I suppose, but Florida has said this is a condition precedent, so it's more than just punishing them through insurance.
Is Palma the same situation as we have here? It's not clear to me how the holder or the servicer stands relative to NationStar and Bank of America.
NationStar is the holder and servicer.
Right.
So this is the same situation as Palma and De La Cruz, except that there was a service transfer from Bank of America to NationStar before the suit was filed. It's exactly the same,
But
except for that.
In Palma, then, the servicer could have done the face-to-face meeting prior to filing suit. I mean, there's not a transfer like we have here.
Well, but there's no, I agree, but there's no reason that NationStar couldn't have done that either. You know, in the defense case and trial, the NationStar witness acknowledges that they didn't have any procedures for seeing if the prior servicer did face-to-face counseling as part of the boarding process, and he hadn't even heard of that concept until I brought it up in trial. How troubling is that? That you
But
have
if I accept your position, I suppose on the one hand you're enforcing compliance with the regulation. On the other hand, there is some windfall that goes to the borrower, isn't there?
Well, no, I submit it's not a windfall. What it is it's simply a way to ensure that the lender does what it's supposed to do under the terms of federal law, and it prevents the lender from getting away with not doing it, because
No.
that's what they want you to do.
I disagree. The concept is we don't view regulations, statutes, or contracts in isolation, and you're focusing in on this section. And as I'm reading through all the sections in the CFRS, the section 203, including the first subsection of it, the whole point is mitigation loss. The federal government has to underwrite these loans, and they're providing that anyone that wants the full faith and credit of the United States behind their loans, i.e. these banks, these lenders, need to go through efforts to mitigate loss that would have to be absorbed by the American people. I don't see that subsection to relate to be a sword to be used by a mortgager, but instead their regulatory compliance to protect the United States from unnecessary loss in housing when we're backing these loans as the people of the United States.
Exactly. So why are you going to allow NationStar to collect on defaults in 2012 when there was no compliance with this FHA?
The NationStar shall, Bank of America, or any of the other lenders shall be subject to administrative penalty pursuant to the CFR. That is what happens.
Judge, I'm sorry, but that to take that position, that's the position they took in their answer brief. You would have to certify conflict with Palma and Harris to take the position that the only remedies are administrative remedies or something like that.
And
It's a
Mr. Stopa, actually, and perhaps this is why we have 3 judges, I kind of agree with you. The way I see it, and maybe because it's similar when we look at Brandeis and the what is, whether